All right, and we do have this news alert for you just coming in right now. This is going to be the sentencing part that we've been talking about. So let's see if we can listen in as well. This is the Massachusetts woman who was found guilty of involuntary manslaughter for her encouraging her boyfriend to commit suicide.
I'm sorry, it does not?
No, it can be continued.
It can be impounded.
We do not
all right.
object to that at this time.
So, all right. Commonwealth, do you wish to be heard on that issue?
No, Your Honor.
All right. I will impose the same impoundment order as I have. I think on the other records was 10 years. I'll look that up, but I think the other records that we impounded were for 10 years as well.
I could be wrong, but my recollection was that it was a lifetime impoundment.
Or was it? Oh, whatever it is, it will be the same. All right. Again, in an interest of trying to treat everyone with the same level of respect. All right. Okay, I have reviewed the probation sentencing report, which I am sure counsel has also reviewed. I've actually reviewed it several times. And before we start this hearing, I want to take this opportunity to thank Probation Officer Denise Taylor, the primary author of that report, as well as Assistant Chief Probation Officer Cheryl Beauregard, sitting to my right, for an outstanding report. That report was, to my reading, thorough, sensitive, intuitive, and highly professional, and was concise, especially given the amount of records to be reviewed, and to the point. Not only was it professional, but it also reflected a good understanding by both of these probation officers as to the statutory structure that governs this juvenile court. It has been an invaluable resource in my sentencing deliberations. All right, Commonwealth, I will hear from you. Do you wish to present any evidence, Commonwealth, or are you going to just go forward by representation?
Your Honor, with the court's permission, the Commonwealth would like to present 7 family members from the Roy family to read their impact statements, and which time I will read a final impact statement by Lynn Roy, Conrad's mother, and then offer our sentencing recommendation.
All right. Chapter 258B limits those who may present testimony as a victim witness. In this case, given that Mr. Roy, the actual victim in this case, is deceased, under 258B, Section 1, those who may speak are limited to, I wrote it down, in this case, the parents and the sibling, I think, are the only individuals who would be within that parameter of the definition. So those are the people who will be allowed to testify. So you may call the first one if you wish.
Your Honor, the Commonwealth would ask that Camden Roy take the stand, please.
All right. Ms. Camden Roy, please come up. And please remain standing for one moment while you are sworn.
Please raise your right hand. Just mad before the court, so tell the truth, full truth, and nothing but the truth, so help you God. Okay.
Good afternoon, Ms. Roy.
Good afternoon.
It's very, very important that you keep your voice up nice and loud, please, for my benefit as well as the benefit of everyone in the room. Please state your full name and spell your last name for the record.
I'm Camden Roy, R-O-Y.
Thank you, Ms. Roy. Ms. Roy, we're going to try to make this as easy for you as possible. Why don't you tell me what it is you would like me to know and to consider?
So I just read.
You certainly can, yes.
Or not having that one person I've been with every day since birth, here and more, is a pain that I will
Louder, please.
that I'll always keep with me for the rest of my life. Not having my brother always going to be there for me, and knowing that will always haunt me. Knowing I'll never be an aunt to Conrad's children or get to see him getting married is something I never thought I would have to live with. He gave me an amazing 13 years, being my best friend and the best role model any little sister could ask for. Not a day goes by without him being my first thought waking up and my last thought going to bed. Throughout those 13 years with him, I have countless amazing memories that will always be with me. From stuffed animals fights in his bedroom, to him trying to teach me how to throw a football, catch a baseball, and shoot a basketball, to pick me up in his truck whenever I needed him. It's crazy to think that whenever I needed him, he was always there for me. But it's even crazier that now, whenever I need him, he'll never be there for me. And again, I wouldn't trade those short years I've had with him by my side for the world. I'll never get over this pain I feel every day, but I know that he loved me more than any big brother ever could.
Thank you very much. Is there anything you want to say beyond what you have read to me?
No, thank you.
All right, ma'am, then you may step down. Thank you very much. Do you have a further witness?
Thank you, Your Honor. Conrad Roy Jr., please.
All right. That is, as I understand it, the father of this child,
That's
correct?
correct,
Or this young man, pardon me. Good afternoon, sir. Please remain standing for one moment while you are sworn.
Please raise your right hand. Swear before the court, swear to tell the truth, whole truth, and nothing but the truth, so help you God.
All right. Take a seat, sir. Make yourself comfortable. Please keep your voice up nice and loud. State your full name and spell your last name for the record.
Conrad Roy Jr., R-O-Y.
All right, sir. Do you wish to read or do you wish to speak to me directly? What would you like?
I wish to read.
Go right ahead.
I am Conrad Roy Jr. I am Conrad Roy III's father. I cannot begin to describe the despair I feel over the loss of my son. Perhaps I could ask you to imagine the worst emotional pain you have ever experienced and multiply it to an infinite number of times. I am heartbroken. Our family is heartbroken. My son was my best friend. Through the height of his depression, I was by his side trying to build his spirits and to affect his behavior positively, striving to lead him towards the bright future that was before him. As late as July 6, 2014, we were towing a fireworks barge back from Falmouth, and Coco drove the tugboat through the hurricane barrier by himself, with only the guide of a proud father watching over him. Coco was my first mate. In our future, I envisioned teaching him more skills and sharing my knowledge with him. Coco was sensitive, loving, intelligent, compassionate. He was a member of a supportive and wonderful family. His sisters adored him, and he was an excellent older brother. Although he did have some psychological troubles, we all felt that he was heading in the right direction and over the worst of it. Time and positive support from family and friends were critical to his emotional well-being. He had such a bright future. Michelle Carter exploited my son's weaknesses and used him as a pawn in her own well-being. She has not shown any remorse. The fact that my son was convinced to kill himself makes his death unimaginable. How could Michelle Carter behave so viciously and encourage my son to end his life? Where was her humanity? In what world is this behavior okay and acceptable? Coco is missed beyond measure. His family misses him, his sisters miss him, his friends miss him, and I miss him. The last words I said to my son was, "I love you." And Coco said, "I love you too." I miss him every moment of every day.
Thank you, sir. Is there anything you would like to add?
No, Your Honor.
Thank you very much. Ms. Flynn?
With the court's permission, I'd like to read the impact statement of Lynn Roy, Conrad's mother.
Certainly.
I do not know where to begin. When this became a news story, it completely overwhelmed myself, Conrad's dad, and our daughters. I have been doing my best to gain strength from Conrad's two sisters, and they gained strength watching me with doing my best to put one foot forward each and every day. It has been completely hard to be in certain social situations at times, feeling so broken. I have only been to a few court hearings, not that I didn't want to be there for my son, but I know that it's something that brings me more pain that I could not handle. I still cannot come to terms that another person who knew and described how much they loved my son would want to inflict so much pain on myself, his dad, his sisters, and all who loved him deeply. He is the most amazing human being and would have had a bright future. He should have been navigated into a positive direction. He certainly was, with his support from his family. He accomplished more in his short life than some do in a lifetime. I know deep inside my soul, and I think often of my son's soul, and what a beautiful, selfless soul he was, that he would never want us to endure this pain with losing him. But what comes along at his court hearings is that he believed that social media was corrupting his generation. It is unfathomable to believe why someone would want such an amazing, young, caring man and everyone who loved him to carry this throughout the rest of our lives. There is not one day that I do not mourn the loss of my beloved son. Every day I strive to be a better mother to his sisters and a better person for him. I want him to be proud of me and how I am handling everything. I am trying to be there for his sisters in the best way that I can with all of my pain that we will carry with us until eternity. This does not stop after a trial. I pray that his death will save lives someday. I said to myself, in honor of Conrad, I need to handle this in the best, graceful way that I can. Conrad always wanted to help others. I cannot put into words what an honor it has been to be his mother. I am very blessed to have spent 18 years and 10 months with him. Every day I will continue to honor him. I pray that a law comes forth that another mother, so that another mother does not have to endure what I am. I thank everyone that has put their heart and soul into Conrad's life. They have been the voice when I cannot. I do not believe that another can go on to encourage someone to take their life, and it can be okay. My life will never be the same, nor his dad's, nor his sister. Camden and Morgan deserve so much more. Thank you, Your Honor.
Thank you very much, Ms. Flynn. So again, the statute provides any spouse, child, stepchild, sibling, parent, dependent, or legal guardian of Mr. Roy. Is there anyone else who falls within that category that you would like to present?
No, Your Honor.
All right. Are you to argue for the Commonwealth?
Yes, Your Honor.
And I will hear you.
Thank you. Your Honor, the Commonwealth is asking this court to impose a sentence of not less than 7 nor more than 12 years in state prison. Your Honor, as the evidence proved, the facts in this case are egregious. Your Honor read thousands of text messages and knows how the defendant undertook a deliberate, well-thought-out campaign to cause the death of Conrad Henry Roy, quite simply for her own personal gain and quest for attention. What a travesty. There is no earthly reason why Conrad Henry Roy should not be here today with his loving family, enjoying life, sharing his many gifts with the world, but he is not. And the reason he is not here is the defendant. Michelle Carter, her actions killed Conrad Roy. She ended his life to better her own. Now she has been convicted of a very serious crime, deserving of serious punishment. It is true that rehabilitation must be a part of any sentencing scheme. But in order to be rehabilitated, one must accept responsibility for their actions. To this date, the defendant has not accepted responsibility for Conrad's death. She has blamed it on his fragile mental state, his family situation, her right to free speech, or the medication that she was taking. She has shown no remorse, and in fact, after Conrad's death, it was quite the opposite. She sought attention and sympathy for herself. It wasn't enough that she took Lynn and Conrad Jr.'s only son, or Camden and Morgan Roy's older brother, or Tom Gamble's best friend. In the aftermath of Conrad's death, she continued to use and deceive all of them until she was caught by her own words. And I would submit to the court that had not the Fairhaven Police Department confronted her, she would have continued her charade as the grieving girlfriend quite possibly forever. And I would ask you to recall one of the text messages she did send to Conrad, where she told him that she felt played and made a fool of by him because he hadn't killed himself yet. But after his death, she became the player. She manipulated and deceived his family into believing she tried her hardest to save him. She lied to the police about her role in his death. She failed to mention anything about what she did to her own parents or to her treating therapist. She duped the town of Plainville and the King Philip Regional High School when she brought Homers for Conrad to their community, collecting money as a way to bring awareness to suicide prevention, when in fact, she was the cause of Conrad's homicide. The defendant is asking this honorable court for probation, and the Commonwealth suggests that is just not a reasonable punishment for the death of Conrad Roy and the tremendous pain and suffering that she has inflicted upon his family, his friends, and the communities that both she and he lived in. Nor would probation serve to help her in any rehabilitation. The Commonwealth is aware that the court has many factors to consider when coming up with a sentence that is appropriate in this case. Some of those, of course, are the nature and circumstances and the seriousness of the offense. What can be more serious than the death of an 18-year-old, such a promising young man who will never walk the face of this earth again? The victim impact statements you heard from the family members of Conrad Roy. These two young girls will never have an older brother. Lynn and Conrad Jr. have lost their only son. She does not have a Board of Probation record. The Commonwealth concedes that. But another factor Your Honor must consider is the probation report, and I again, and the Commonwealth agrees, it was quite a telling report. Certain things that were important for the court to note and that the Commonwealth took note of was that the defendant had an inability to be honest with her therapist, and there was a lack of awareness in her parents about what she was up to, what her treatment was, and what they should do in order to improve in not only her health, but other things that were happening in her life. They simply didn't know. Another factor Your Honor could consider is a lack or a success or lack of past treatment. And again, the records bear out she was not benefiting, nor did she follow through with her treatment. Many times she was recommended to go on to do further things, and when things weren't going her way, she and her parents stopped treatment altogether. This is not someone that can stay in home confinement and get better or even understand the ramifications of what she's done. And of course, we read through the letters from the defendant's memorandum. And again, the Commonwealth is concerned that her support system just does not get the impact of what she did. And I say that because of the terms that they used in their letters. They say things like, she made a mistake. She showed poor judgment. She didn't comprehend the severity of her situation. She was helping Conrad to achieve his goal. They don't seem to understand it was her plan. She was the one on the other end, goading him, telling him to get back into that car. She was the one that for weeks berated him. She never told any of them that, and even after his death, and even to this day, she says she didn't know how to call an adult for help. Your Honor, another consideration Your Honor would look to is the defendant's age. Now, this is a youthful offender, but she was 3 weeks away from her 18th birthday. We're not talking about some immature 14-year-old girl. We're talking about 17 and 3-week-old young woman who was involved in DECA, who was a very responsible student, who knew how to call the police because she said it to Sam Boardman. All I had to do was call the police, or even simpler than that, all I had to do was tell him that I loved him, and he would have gotten out of the car. But the Commonwealth suggests it's even simpler than that. And as Your Honor suggested and stated in your finding, all she had to do was say, get out of the car, get out of the truck, and none of us. For all of these reasons, Your Honor, the Commonwealth respectfully asks this court to impose our recommendation. Thank you.
Thank you, Ms. Flynn. Who speaks for the defendant?
No.
Mr. Cataldo, do you have any evidence to present?
No, Your Honor, other than the submission in the memorandum that you already have.
And I have read those.
Thank you.
Given them the same degree of attention that I did to the probation report. I would just say in passing, although certainly there has been no emotionalism, nor will there be in my determinations in this issue, that all of those letters, the letters of the Roy family, including those that I heard from today, and the other letters attached to Ms. Taylor's report, and the letters of Ms. Carter's family, give this court a fuller understanding of what these two young people were about. Go ahead, Mr. Cataldo.
Thank you very much, Your Honor. Your Honor, the defense is requesting, as you've seen in our sentencing memorandum for your consideration, a period of 5 years of supervised probation with various conditions, including mental health counseling and evaluation, and following the recommendations to be supervised by probation of any and all mental health treatment that the evaluation comes back and recommends to this probation department, as well as having no contact with the Roys except as a pending lawsuit, other than in connection with that, Your Honor. And the other conditions, whatever other conditions this court would deem fair and just and reasonable under the circumstances. Based upon the reasons, the background information gathered, and I won't go through the entire report, obviously, of the probation department and the sentencing memorandum submitted by the defense, Your Honor, I will summarize by saying, as this court is well aware, we're guided with the idea in the juvenile justice system that the goal is not punitive, but yet rehabilitative. Ms. Carter was 17 years old at the time. We have a body of law from both the United States Supreme Court as well as the SJC about the adolescent brain development which a court can consider on sentencing. And there is the clear body that says adolescents are not as culpable as full-grown adults. Ms. Carter does not, I suggest to this court, pose a danger to the public. I suggest that this sad, tragic manslaughter that she has now been convicted of was a very unusual set of circumstances unique to these two individuals, Conrad Roy and Michelle Carter, who are both struggling with mental health issues themselves. Ms. Carter, as this court has seen, both from the probation department's report as well as through the course of the trial, had her own issues. She had her own troubles dating back to the year, going back 3 or 4 years to 2011, where she was inpatient and treated for various eating disorders. And she was put on antidepressants back at that time, which she remained on these antidepressants until the year 2015. Ms. Carter grew up in Plainville, Massachusetts, lived her entire life here in Massachusetts in Plainville, went through the public school system, and graduated ultimately from King Philip School. All while the case was brought in 2015, she was able to graduate. Throughout the course of her history in the public school system, there is no evidence, and probation has verified that there are no records of any kind of disciplinary problems against Ms. Carter whatsoever. There's no criminal history, there's no involvement with the court system, delinquency, there's no involvement with DCF on Ms. Carter's, in her various growing up. She has had no criminal history whatsoever. I suggest, again, Your Honor, this was so unique, these two sad individuals taking these medications, and they were, you saw the full texting, respecting the court's decision of the conviction, but you saw the entire texting history and the evolution of the history. And I do think, just to touch upon that for a minute, there was an evolution of the history. The text messaging does not show that Michelle Carter just came up with some idea when they first started texting back in 2012 or 2013. Your Honor, Ms. Carter went on after high school. She did get accepted to college. She did not go to college as a result of the publicity connected with this particular prosecution. But during the time, she did further her education with online classes. She then took classes. She hopes to get involved in real estate and get a broker's license. She's been doing that. She was placed on strict conditions of her release back in 2015 when this case was pending. She has not violated any of those conditions of her release. Again, these are reasons why I suggest that she would be a successful candidate for probation and rehabilitative treatment in the community and not incarceration. Ms. Carter will have to live with the consequences of this for the rest of her life, with the publicity that this case has gained. That will be substantial. I think treatment is appropriate in this particular case for Ms. Carter. Your Honor, you have in the various documentation that she's still in counseling, verified by probation, that Ms. Gail Holmes opines that she's not a danger to the public, and specifically, as the court saw, that Ms. Carter does regret what happened. She also sent a letter to the probation department where she accepts responsibility for her actions, her words, her letter. The court has reviewed all this. Your Honor, I suggest that she is not a danger to the public, and in the remedial system, the juvenile system, probation is appropriate. Sadly, Ms. Carter herself was in treatment for nearly 4 or 5 years, but in particular, in considering what the just disposition of this case should be, Your Honor, I ask you to take particular attention to what transpired in June of 2014 to Ms. Carter. She did go back, and you have seen these records, that she did go back into McLean, or she did go into McLean Hospital inpatient, where the texting with Conrad Roy really escalated during this time. She was inpatient for bulimia. She had previously been anorexic. She was under taking SSRIs, taking antidepressant medication during this time. She is released from McLean in this critical time, and she begins counseling with Anchor Counseling. You've seen those records. She tells the counseling at Anchor, you've seen these records, that she was overwhelmed by her Conrad Roy's suicidal ideation. The fact that she did not do what ultimately this court has opined or stated that she should have done. I asked the court, however, to now, even though it did not absolve her from criminal responsibility, to factor that into its disposition, that she was going through some significant mental health issues herself. And during this time, prior to July 12th of 2014, Ms. Carter did get diagnosed with depressive disorder herself through the Anchor Counseling that she was involved in, Your Honor. You've also had the various character letters from many of the people who are here from the Carters, showing that she has a support group. Both family and friends submitted letters giving you the idea that this was out of character for Michelle Carter. This is not who Michelle Carter was. She was struggling at that time. And this is not the kind of behavior that had been exhibited in her prior history, nor is it something ever likely to happen again. She is now still in treatment. She is now off of any kind of medication, but she is treating with Gail Holmes, as you've seen and verified through the submissions that were given to this court. The fact that she has had no history with any juvenile court or any governmental bodies such as DCF, Your Honor, I think is very important in this case. In the totality of the circumstances, I think that she would be a successful candidate for probation, and there's nothing in the history that said that she would not abide by any of the conditions as laid out by this court. I don't think it's at all a long shot to say, well, we may give her a shot on probation, but I don't think she's going to make it. Her history dictates, I suggest to this court, that she would make it on probation with mental health treatment and counseling. For those reasons, Your Honor, we are asking, as I've laid out in detail in the memorandum, to give her an opportunity to show this court and the community as a whole that this was a horrible circumstance that she completely regrets and does, in her letter, take responsibility for, Your Honor. But it was at a point in time in her life, and sadly as well as Conrad Roy, that these two young individuals sadly came together and resulted in the tragic death of Conrad Roy. But I do think, given that this ultimately is a juvenile court, and given the body of science and the case law, that she is the kind of person that should be given a chance on probation to make it. And any and all conditions, as this court were to lay out, you can be sure that she would abide by those conditions. But this is a terrible, terrible tragedy. And she very much regrets this and prays Your Honor's judgment of leniency in this sad circumstance where she herself had mental health issues going on. Thank you very much, Your Honor.
Thank you very much. I'm going to take a recess until 10 minutes of 3 to reflect upon these cogent arguments made by both sides. I will be back at that time to render the decision.
All rise. You may be seated.
All right, everybody, what looks like they are taking a short break during this case right now. What do you think so far, Mike?
Well, the judge is now going to deliberate and think about what the prosecution said. And, you know, we did hear from the victim's dad, and then we heard a statement by the victim's mother. So it's going to be interesting to see where the defense right now wants 5 years probation. Obviously, the victim's parents and loved ones
do not feel that way.
Yeah, they want, and it looks like we just lost that shot momentarily. So just, there we go. So hopefully we'll get that feed back up for you. But yeah, like we were saying, the
defense wants her, what, 5 years probation?
5 years probation. The victim's family wants the full 20.
Right.
So it's going to be interesting to see, because you're dealing with someone who, like the defense said, doesn't have a record.
Right.
Never been in
Young.
trouble before, yes.
What is she, 17?
Well, she was 17 at the time.
Yes.
So it's been a couple of years removed here, but obviously a story that when it first came to the attention of everyone's really shocked by that sort of news.
I know, and like Ron Hoon was saying earlier when he was up here on your show, this is a very different kind of case, because now you can try people for murder without a weapon, wasn't even at the scene, but she sent him text after text after text asking him to kill himself. And so a new kind of case, we don't see this all the time.
No.
But in our generation now, this is something new.
It's certainly new, and it's so devastating to see stuff like that and hear about it, because it's one thing to hear about a case like this and you're thinking, oh my gosh, that is just absolutely horrible. But then if you go text by text and read, I mean, it's pages and pages.
So she's literally
text.
begging him to do it.
Almost, yeah.
It's not just one text.
No, where it just keeps on coming. So unfortunately for that boy and the family, that is something that they'll never have their boy.
Yeah, it's so sad.
And now the
other family will never have their daughter again if she gets sent away for the maximum sentence too.
Yes.
And it's hard, because in this generation with kids, they're texting, they're Snapchatting. Parents are left in the dark so much now with what their kids are really doing, because we're not playing outside anymore. We're dealing with kids who are inside on their computer doing who knows what. If you don't have extremely strict parents, what parents really have the time to monitor everything they're doing on their cell phones, on their computers? That's so hard.
I know, and it begs the good question of really what is going on with your kids or your loved ones' messages. You don't know, when you're maybe at a family dinner and you see them just going down it, you don't know what that conversation is.
Exactly.
You don't know who they're chatting with or texting with. So
exactly.
Yeah, this brings up probably a good question for everybody, for every family member, to have maybe a conversation with their loved ones.
Yeah, how much should you monitor your kids' texts? I mean, her parents might have had no idea and might have not even known their daughter was capable of this sort of anger and what would you call it? She wanted people to feel bad for her, that her boyfriend committed suicide. That was her main motive in this. What is that? Insecurity, sort of self-involved. You want that sort of attention in school. Again, young girl, but maybe her parents probably had no idea.
No.
Why were you texting this boy like this? You know, I mean, it's
definitely, and
it's crazy.
We just heard an update that the recess will continue until 11:50 Phoenix time. That's 2:50 out on the East Coast there in Massachusetts. So we should be getting that feed back. You know, they don't give us the feed when they are in recess right now.
Right.
So right now, if you're just joining us, everyone, we did hear victims' statements from not only the father but also a statement from the mother, and then we heard from Michelle Carter's defense lawyer talking about they're pushing, the defense team is pushing for 5 years probation. Obviously, the victim's parents want the full 20 years.
Yes. And
that's the max that she could get.
And I think this is such a big case, and everyone's really interested in this because everyone seems to have different opinions about it. Some people say send her away forever, what she did was terrible. Other people are saying, yeah, she was asking him to do it, but they were just texts. How can she really be sent away for the full time? It's not like she did it herself. So each side, two different sides to this story. A lot of people feel differently. I was noticing a lot of comments in the chat section. It seems like a lot of people are leaning more on the side of send her away, what she did was wrong. But other people are kind of taking the side of her, saying she was young. So I think that's why people are so interested in this.
Yes,
you know?
Definitely. And right now, we're sort of like tri-streaming, not dual streaming, but tri-streaming right now, because not only are we on Fox 10 Extra, not only on fox10phoenix.com, but Facebook Live as well.
Yes.
So we got a lot of different avenues here, and I know if maybe some of you are just joining us here, you're waiting, okay, did we have the sentence yet? Not yet, but the judge is making that decision now, and we're expecting it at about 2:50 Eastern, 11:50 right here, Phoenix time, for all of our local viewers right now. But you're right. This is a case that when you first heard the headlines, you were like, what? And you had to read it, and then you thought, okay, this is just so bizarre.
It's such an interesting case because this doesn't, but now I think these are the type of cases we're going to see now in this sort of digital generation that we live in, where she's being tried for texting him and telling him to kill himself. But again, like you said, it wasn't just one text, it was pages of texts.
Yeah, you really got to look at the totality of the text. And if you're really big into this case, you could always, go on Google and search for the full transcript.
Yes.
And
it's so long, right?
You
said that you read most of it.
And yeah, and there's a certain part where it's really telling, where you could tell that the guy did not want to go through with it, or he was having second thoughts. And then she almost implies saying, I knew you wouldn't go through with it. Like, that right there is just over the top. Times 50.
And that's so strange. Why would you want to do that? I'm just wondering what's really going on in her head. I know that we were told that she was possibly on antidepressants, but is that an excuse? I mean, just because you're depressed doesn't mean you want other people to kill themselves. At least I don't think. I don't remember that being a common side effect of being depressed.
No. Yes.
So, okay, what else is going on in her head? Why would you honestly want your boyfriend to do that? We all say things when we're mad at each other, but she really seemed to want this to happen with all of those texts.
And it's a case that we've been following for a while, and we will be waiting for that sentencing coming up in just a little bit. And we continue on here on Fox 10 Phoenix Facebook Live, as well as fox10phoenix.com. So, we're just waiting. We're in a holding pattern right now.
This is great too, because they said they're going to come back at, would you say, 11:50? So we've got about 5 minutes to just continue discussing this case, and hopefully we'll be able to hear some sort of conclusion of some sentencing. I know that both families want to have some closure on this case. It's interesting, though. I'm very interested in this case because this girl seemed to really want this to happen. And then you see her crying her eyes out in court. And I said, why do you think she's crying so much? And you said, I don't think she thought she would get caught. I wonder, did she really not think that his text would still be there on his phone when the police found him?
Yeah.
She must just have not thought about it. I
No,
mean, you're
and-
young, you're 17.
And you got to think, there's always a paper trail, though. Even though you might even be able to delete text, you know
Yes.
there's a way to, they could scrub and find it.
Yeah, absolutely.
That's why we always, if you watch those like CSI type, they are always digging.
They're always finding missing messages and things. I mean, you can contact the phone company
Yeah,
and get
and even,
information.
and we're even learning, you know, for folks that love Snapchat. That's another,
Yes.
just because you send it to one person or you think it deletes right,
It
it's
doesn't.
There. It is there.
It
So
doesn't. I'm
maybe
sure
that
if
could
you
be
read-
a wake-up call to, yeah.
Yeah, absolutely. Yeah, I'm sure. I was just going to say, I'm sure if you read the fine print of Snapchat, they probably own the photos that you're sending that you believe are disappearing.
Yes.
I'm sure they, you know what I mean? You got to be careful.
Yeah. Yeah, so if you're just
So-
joining us, everyone, welcome to the stream. If you're on Facebook Live or fox10phoenix.com, let us know in the chat what you are thinking and what do you think probably may be the possible outcome with this story here. I know it's a story that a lot of people have been talking about. We have a lot of people in the stream watching. You guys want to see how this is all going to wrap up as well.
Yeah, absolutely. We've been streaming again. We're on Fox 10 Extra, Fox 10 Phoenix Facebook Live, and Fox News Now YouTube stream. So we thank all of you guys for joining us here on the show today. I know a lot of people are really eager to hear the sentencing. If you
Yeah.
were to guess, what do you think's going to happen? I mean, do you think it'll be the 5 years probation, or do you think she'll get the full time?
Yeah, I think it's a toss-up. So we do welcome everybody that is coming back here on Fox 10 Extra as well. Mary Kate was just asking me, what do you think could be the outcome, the judge's decision? That's what we're waiting on right now. And like I say, because she didn't have any priors, I wonder if it's
Yeah.
going to go the probation route. And I know the
Yeah.
victim's family would just, I mean, that would just be utterly devastating there.
Yeah, that's, it's really hard. I can't make a really accurate guess. I have
Yeah.
no idea what way they're going to go, but you make a really good point. She doesn't have priors. She was 17 at the time.
17 at the time. So, yeah, it's going to be interesting. Her lawyer argued that the guy was determined to kill himself and nothing that Michelle Carter did would have changed his decision. He also argued that Carter's words were protected as free speech by the First Amendment.
So let's discuss that. How far really can we take the First Amendment with things like that? Free speech, but when you're begging I mean, literally telling them, I knew you wouldn't do it, you gotta do it, don't be afraid to do it, you've gotta kill yourself. Free speech, I mean, I guess we're all entitled to say what we want to say, but see, that's a fine line there. It's a
And
fine line.
when you look at, like I was talking about earlier, the totality of all the messages, it'd be one thing, I think they'd have a real solid case if it was just one text.
Sure, yeah, like, she didn't mean it was one text, she said it out of emotion, but a series of texts.
A series.
That's deliberate,
Where
I would
it's
think.
pages long on the transcript. I don't know. So it's going to be interesting what the judge's ultimate sentencing will be. We've they're on a recess right now, but they said about 11:50 Phoenix time, 2:50, and just like that, they were
Just
pretty
like
much
that.
right on the dot. So let's go. We're just getting that feed back in. Let's take you there right now and see if the judge is not there yet. But it looks like he could be walking up to his seat at any moment. If you're just joining us, everyone, we are awaiting the sentencing for this Massachusetts woman, Michelle Carter. This is the woman in the suicide texting case. She will be sentenced.
And again, if you guys missed the beginning of this case, don't worry, we'll have it clipped in full. Just head to the video section on our YouTube page. You can search for Fox 10 Phoenix. It'll be there at the end of this hearing, and you can watch the entire case in full.
Yes, Carter was convicted of involuntary manslaughter for encouraging her boyfriend to kill himself, and she could hit that 20 years in prison at her sentencing today. So we also appreciate everybody also tweeting us as well as being in the chat as well.
Yeah,
There.
let's take a look at the chat, just see if there's any opinions. I know that we were kind of talking about a lot of people have different opinions about this case here. Let's see. Yeah, Phantom saying murder by cell phone. Phantom, that's kind of what people are saying, is that she, the other side, his family saying that she literally murdered him by her own words, telling him to kill himself, while the other side is saying, you know, she was far away, she was young, she was texting him. A lot of different opinions in this case, so we thank you guys for adding your opinions here in the show.
And we are continuing to right now. This is Mary Kate. I'm Mike Page. Thanks so much for continuing to watch with us. And for our viewers on Fox 10 Extra, if we are not able to get that decision in before this broadcast does end, we always encourage you to go right to fox10phoenix.com. Get that ready, because we'll have that in its entirety as well.
Yes, and we're continuing to stream this live online. So anyone that's watching it online, you will hopefully be able to see this sentencing. We'll stick with this the entire stream here. Norbert saying that he thinks that she'll get the 5 years probation.
Okay. So it's something
we'll see.
Yeah, it'll be very interesting to see. We've all been waiting. We've been seeing the headlines. We've read the transcripts of these text messages. I was saying earlier, if you didn't read these actual texts, they have the whole transcript.
Online.
You could just Google it there, and definitely, if you're into this case, I think you would want to read them. And what I was thinking about, Mary Kate, was, say this wasn't text message based. What happens if this was all just by word of mouth?
Like over the phone, or just saying it face to face?
There would have been no paper trail, and that would have been hard to prove, right?
Yeah, absolutely. That would have been very hard to prove.
So earlier, you brought up a great point about, you think because of this whole social media phase and craze really that we're in, that you think we could maybe potentially be seeing more of this in the future.
Yeah, I think so, absolutely. I think that there's already cases out there, not necessarily as serious as these, but people, my friend's dad is a divorce lawyer, and he said now he has to incorporate social media in almost all of his cases, where it's, you know, through Facebook, social media posts and so on. Looks like they are back.
So let's go back to it right now, live.
Before I give some of my rationale, and let me say that Section 58 of Chapter 119 requires that written findings be entered. I have done a draft of those findings, but I will do a final draft to incorporate the positions of the parties in this case, and to reflect in that final decision on the impact of those arguments by Mr. Cataldo and Ms. Flynn. And of course, I had already read all of the letters that were reread to me here this afternoon, but certainly the effect of having them read to me by these people whose lives were so touched by Mr. Roy's passing was a consideration. I would say that those letters, those statements, the letters that accompanied Ms. Carter's sentencing memorandum, as I said earlier, gave a fuller understanding of both of these young people. But it also highlighted perhaps what has been the most poignant comment made by anyone in this trial, and that was by ADA Flynn, that this is a tragedy for two families. You need to understand, however, all of you, that this court has not, nor should it, allow any emotional response to this case to enter into its determinations in any way. Everyone is entitled to a decision devoid of any emotion with respect to this case. The relevant provisions of the law with respect to the juvenile court to this case are Sections 53 and Sections 58. Section 53 provides that notwithstanding the fact that, as Ms. Flynn so well pointed out, Ms. Carter was approximately 3 weeks away from what that law considers to be adulthood, she was still what Section 53 calls a child before the court. Section 53 says that children before the court charged with crimes are to be treated as children in need of aid, encouragement, and guidance. Section 53 preceded the youthful offender statute by many, many years. It is my opinion that Section 58 and the youthful offender statute, in fact, diluted somewhat the philosophy of Section 53, but the legislature, in its enactment of Section 58, the youthful offender statute, did not repeal Section 53. And so it is necessary that there be a balancing between the mandates of those two statutes. And that is what has guided this court. A comment on a few of the Section 58 considerations, and again, not to be misconstrued as the entire process or deliberative determinations. I have not found that Ms. Carter's age or level of maturity or even her mental illness have any significant impact on her actions. She was a bright young lady, did well in school, and I am satisfied that she was mindful of the actions for which she now stands convicted. So in my deliberations, that has had little weight. On the other hand, as Mr. Cataldo so well pointed out, I am aware of a huge body of law that has developed nationally and within this state, starting primarily with a case in 2012, Miller versus Alabama, and then picked up here in Massachusetts in the matter of Diachenko versus the district attorney, which is found at 466 Mass 655. Although Mr. Cataldo stated one side of it, it is my read of those cases that there is another side. And that is that even if the age and maturity level of the person at the time that they have committed the crime doesn't garner a great deal of significance, the fact that they are still of that young age offers a greater promise of rehabilitation. Now, I know that there has been some significant media coverage of this case. I assure you that I have steadfastly avoided any of that. It would not be proper, nor would I want to color any perceptions of my case by exposing myself to any of that. And I have not done so. But by the end of today, people will wonder why what has happened has happened. People may wonder why all of this has happened. If you really want to understand what we do in the juvenile court and how we come to the decisions that we make, it is all contained in this little pamphlet. This is a remarkable work that was issued by the Administrative Office of the Juvenile Court in April of 2016. It is the Dispositional and Sentencing Best Practices for Delinquent and Youthful Offender Matters. It came together by virtue of a committee that was chaired by an extremely knowledgeable judge, Judge Jay Blitzman, First Justice of Middlesex Juvenile Court, with several other highly knowledgeable juvenile court judges sitting on that same committee, as well as representatives from District Attorney's Office, CPCS, which represents the majority of children in the juvenile court, DYS, and many other agencies. When I first prepared my remarks for today, I took this book out and I started making purple marks on it and things that I would want to present to people to understand the context of what is going on. There were so many purple marks, I said I'm not going to do it. But if you really want to understand the juvenile court, read this document, because then you will understand what we are all about here. And as Mr. Cataldo said, we are the juvenile court, a unique and special aspect of the Massachusetts trial court. That document, Diachenko, Miller versus Alabama, all indicate that this court must and has considered a balancing between rehabilitation, the promise that that rehabilitation would work, and a punishment for the actions that have occurred. And so I have done so. Ms. Carter, please stand. Ms. Carter, a guilty finding having entered on the indictment charging you with the involuntary manslaughter of Conrad Roy III, now sentences you to 2.5 years in the Bristol County House of Correction. 15 months of said sentence shall be deemed a committed sentence, and the balance thereof shall be suspended until August 1st of 2022. You will be on probation, administrative, until you are released from incarceration, supervised thereafter, and the date of probation commences today. While you are on probation, there will be the usual conditions of probation, which include that you will obey all court orders and all local, state, and federal laws. You will report to your probation officer as that individual directs. You will allow the probation officer to visit in your home or school with or without notice. You will notify your probation officer within 48 hours if you change your residence, school, or employment. You will report to your probation officer within 48 hours after you are released from incarceration. You will not leave Massachusetts unless you get permission of your probation officer and sign a travel permit. You are required by virtue of your conviction to submit a DNA sample, and that will be done through the probation department. You will sign all releases as necessary for probation to verify your compliance with its terms, and you will pay all court-ordered fines, costs, and assessments. Those are the general terms. There are, in addition, specific terms. You are to have no contact with any member of the Roy family, excepting only that as may be necessary in conjunction with any civil litigation, including but not limited to the matter of estate of Conrad H. Roy III versus Michelle Carter, docket number 17-0846. You will have no contact, direct or indirect, with any of the civilian witnesses who testified at this trial, excepting only Dr. Bregan. This shall include, but not be limited to, Ms. Samantha Boardman, Ms. Alexandra Eblin, Ms. Ali Ethia, Ms. Olivia Mosoglo, pardon me, and Thomas Gamble. Upon your release from incarceration, you shall present yourself within 48 hours to the Bristol County Juvenile Court Probation Department, Taunton Division, and thereafter shall follow all regulations as indicated by that probation department as to reporting requirements. When you report to probation, you will arrange through probation to schedule a mental health evaluation, which will be done by our juvenile court clinic. Said evaluation shall be for the purpose of addressing areas of need as to any mental health issues and to make recommendations for the treatment thereof. You will be required, as a condition of your probation, to cooperate with that evaluation and to follow those recommendations. A copy of the evaluation shall be provided to the probation department, but shall not be filed with the clerk's office. You shall also sign releases of information providing for any service provider from whom you are receiving services related to the mental health treatment to probation, allowing probation to receive information as to your attendance, the purpose and goals of your counseling, a general statement as to your cooperation with that service, and progress toward the stated goal. Said mental health services shall continue for as long as deemed necessary while you are on probation by the clinician or individual providing same. This court further orders, and this will be in writing, all of this is in writing, this court further orders that any disclosures made by Ms. Carter during the mental health evaluation or the treatment recommended may not be used in any substantive way at any subsequent evidentiary hearing that may occur relative to this matter to establish any of the elements of any crime, including this indictment, in the event that for whatever reason it is retried. Based upon this court's analysis, that to some degree, and drawing on Dr. Bregan's testimony, that he spoke in terms of behavior of grandiosity, and this court's assessment that for whatever reason, part of the motivation for this activity that led to your conviction was a sense of self-aggrandizement. This court now orders that you are not to profit from the events of which you now stand convicted and the facts surrounding same. For those counsel, I refer you to the case of Commonwealth versus Power, 42010, and the cases that are cited therein from 1995. You, Ms. Carter, your assignees, and any representatives acting on your authority are prohibited from directly or indirectly engaging in any profit or benefit-generating activity relating to the publication of facts or circumstances pertaining to your involvement in the criminal act for which you now stand convicted. This shall include contracting with any person, firm, corporation, partnership, association, or other legal entity with respect to the commission and/or the reenactment of the crime by way of a movie, book, magazine article, tape recording, recording of any type, radio, television, or internet presentation, interview, live entertainment of any kind, or from the expression of your thoughts, feelings, opinions, or emotions regarding such crime. Any action taken by you, whether by way of execution of a power of attorney, creation of corporate entities, or like action to avoid compliance with this condition of probation, shall be considered a violation of the terms and conditions of your probation. As I noted, your probation shall be administrative until you are released from incarceration, and thereafter shall be supervised. The probation supervision fee is waived. A victim witness fee in the amount of $45 is imposed, and that shall be paid on or before September 11th of 2017. And finally, as I noted a moment ago, you will be required and must submit a DNA sample in accordance with General Laws, Chapter 22E. That is the sentence of the court. You may be seated. Mr. Cataldo, do you wish to be heard?
I do, Your Honor. May I approach?
You may. Thank you.
Your Honor, what I have just filed is a motion to stay the execution of the sentence.
All right, let me take a look at it, please.
Okay, thank you.
I'll hear you, sir.
Thank you very much, Your Honor. Your Honor, you have now reviewed the motion to stay the execution of the sentence. Your Honor, the issue is that not whether or not the defense, we need not establish that the appeal is more likely than not to be successful, but only that it presents an issue which is worthy of presentation to an appellate court, one which offers some reasonable possibility of a successful decision on appeal. Your Honor, I have, this is not an exhaustive list by any means, but I refer the court back to the motion for required finding of not guilty for the other issues that we presented during the course of the trial, as well as some issues that have been presented in the court's ultimate decision to find Ms. Carter guilty of involuntary manslaughter. I would argue to the court, and I do argue to the court, that this is a very unique and despite the court's findings, novel issue involving speech alone, without presence, without physical presence. As the SJC even noted in their decision that went up pre-trial on a probable cause standard, they had never encountered a case where speech alone, where there wasn't physical presence, had come up before. I suggest that this is a fertile ground, a very important legal issue that needs to be pursued in the appellate courts for however long it takes to whatever court needs to address this very issue. There are many different issues involved in the appeal that will be coming. You have the Levesque issue, as the court noted, that she owed Conrad Roy a duty of care by a self-imposed created duty. While the judge yourself said that, we do take exception that the fire, if you will, was not created by Ms. Carter, but was created by Mr. Roy. That's another issue that we would be presenting to an appellate court. This court has already, and I won't go through each and every one of the motion for required finding, but I think this court is, it realizes that there are many issues in this trial and the uniqueness of a manslaughter without a statute for assisting suicide and the implications in the First Amendment that this case will have or could have once an appellate court ultimately rules on the First Amendment. So, Your Honor, the idea that even if the appellate court were to deny it, these are legitimate issues that are worthy of presentation, and it's something that the appellate court will ultimately may not rule on by the time Ms. Carter, if she is ordered to serve her sentence immediately, would already be out, would already be released. So for those reasons, Your Honor, we think that this court should issue a stay of the execution. She would be on probation immediately. She would have to do everything else and begin with all her conditions, but the incarceration portion could never be taken back if the court does not stay that particular issue. Further, Your Honor, as this court knows in issuing whether or not, in deciding whether or not to issue a stay, is whether or not Ms. Carter might be a flight risk. I think that is extraordinarily minimal in this case, that she would be a flight risk. She's always appeared in court for the past 2 years while this case has been pending. She has not defaulted. She obeyed each and every term and condition of her pretrial release. I would suggest that she will go ahead and start with her probationary conditions, but just we're asking to stay the portion of the sentence that would dictate that she be incarcerated immediately. Your Honor, there are a lot of legal precedent, not just in Massachusetts, but from around the country, on the issues of whether or not speech without using true threats can be curtailed without a statute in place. These issues need to be litigated in an appellate court ultimately, and we're asking you, Your Honor, to stay the jail sentence until we can have our day in court in the appellate level of whichever court ultimately it goes to be the final arbiter determiner of the First Amendment, as well as the idea of the duty imposed on Michelle Carter and all the other issues on the motion for required finding of not guilty, some of which, Your Honor, were not presented on Commonwealth v. Carter, the SJC previously issued in 2016. There were some other issues, as this court notes. So for those reasons, I'm asking the court to stay the execution of the jail sentence of this case.
Mr. Cataldo, before you step away from the podium, sir, assuming I was to allow this motion, I have some concerns that extending a stay until the federal appeals are done might create two problems. And the first is that the statute seems to suggest that the stay ends when the rule, pardon me, seems to suggest that the stay ends when the appeals court issues its rescript. So how would I be able to extend a stay beyond the issuance of a rescript by the Massachusetts Appellate or SJC? And then the second issue is, assuming that this wended its way through the federal court system, the date of August 1st, 2022 could have come and gone before Ms. Carter is required to serve her sentence in the event that ultimately my decision is upheld.
First question, Your Honor, on the rescript, I would suggest if a rescript were to come down and it is in Ms. Carter's favor, and secondly, if it came down against Ms. Carter's appeal on all the various issues, I would suggest, depending on which court, we would be asking that court at that time for a further stay.
Which I think begs my question of why, if I am to allow a stay, why should it not just be through the Massachusetts appellate court system? And then beyond that, you would have to obtain relief from the appellate level.
Well, I guess let me start by saying that is now my fallback position to this court. But I do think each and every level as we go up, and if it is ultimately denied by the SJC and there is a petition for cert or some other federal relief that we are looking for, then it would be incumbent upon the government move to terminate your stay at that time. But I think that the court should issue the stay and through all appellate procedure, but at least through the SJCs, and then if the court were to put the burden, if you will, for lack of a better word, over to the defense, I'm sure we'd be seeking it in a federal court. But if not, then I suggested it be on the government to then file for a revocation of the motion to stay.
Well, I think under the rule, clearly, once the rescript opinion issues, it is on them. But, and I suppose I should say at this point in time that although I have been very involved in this case, no one should assume that I have taken exclusive jurisdiction of it, all right? Because I don't know how much longer I will be here. So in any event, please feel free to bring whatever concerns you have in front of any juvenile court judge. Thank you, Mr. Cataldo.
Thank you, Your Honor.
Ms. Flynn and Ms. Rayburn, do you wish to be heard?
Yes, Your Honor. Commonwealth vehemently would ask the court to deny the motion. The main issue in this case is that the defendant was convicted of involuntary manslaughter. This is not an assisted suicide case. This is not a First Amendment case. The SJC unanimously said that. There is no basis or likelihood of success for her appeal. This is a case that has been a 3-year ordeal for the Roy family. They deserve to have the sentence that you just handed down imposed today. And so the Commonwealth would suggest that this motion be denied.
All right, thank you very much. I guess we have all come to know each other a little bit. I anticipated this motion, Mr. Cataldo, and I took some significant time to review the case of Commonwealth versus Hodge, which is found at 380 Mass 851. I note at page 855 of that decision they are talking about the significance of stays, even though the reporter's notes indicate that stays are not generally the practice here in Massachusetts. It does say, however, that the practice of a stay is grounded in rudimentary notions of justice, that a person convicted of a crime who would a short sentence would otherwise be made nugatory in the case of a short sentence and would be impaired in the case of a larger sentence, and says further, citing Commonwealth versus Levin, 7 Mass App Court 501, the conviction may be reversible, but the time spent in prison is not. I am satisfied under the Hodge language that there is an issue worthy of presentation to the appellate court. In fact, this court believes that the wisdom of the appellate court will be of instruction now and going forward. And that's important. And one of the reasons it's important, Ms. Flynn and Ms. Rayburn, as the representatives of the Commonwealth of Massachusetts, and specifically the Roy family, is the letter of Mrs. Roy, who said that she hoped that the death of her son would result in law that could prevent this from ever happening again. I don't know what the appeals court will do. I don't know if it goes to the SJC, what the SJC will do. But I am satisfied that a grant of a stay through the Massachusetts court system only is warranted. This order will not encompass anything with respect to the federal system. Now, while Ms. Carter experiences the, evidently I have to file this. I'll give this to probation. I have the notice of the DNA. I will give that to probation to go over with Ms. Carter afterwards. All right, and let me give you that now before I forget. Thank you very much. Ms. Carter is going to be out on the stay, and she is going to be, under Rule 31, I have the authority to issue conditions, and that has been enhanced by the use of Chapter 276, Section, I'm sorry, wait a minute. To 76, Section 87. So Ms. Carter will be, although they call it pre-release on the form, it is obviously post-trial, but it applies. And there will be conditions which will track in large measure the conditions of probation. Violation of any of those conditions could result in the immediate revocation of the stay. And I have those written out. I just have to see if I can locate them amongst all my papers. Ms. Carrera, here are the, that's a motion for funds. You can distribute them to the lawyers, and you can give Mr. Cataldo and Mr. Madeira 2 copies so that they have it for the sake of that. I believe there are 2 copies there. Okay? All right. I apparently must have left that other form on my desk. Do you have a copy? Is that on my copy? That's all right. I remember most of it. All right, that will be provided to the probation in about 5 minutes, Mr. Cataldo. But basically, it is the same existing conditions. No contact with the Roy family, no contact with the witnesses, no application for or obtaining of a passport, no leaving the Commonwealth of Massachusetts, and the language from Commonwealth versus Power are all incorporated in the 276-87 order that will enter. And probation will have that in 2 minutes. I must have just inadvertently left it on my desk upstairs. Is there anything further, Mr. Cataldo or Mr. Madeira?
We're all set. Thank you.
Commonwealth.
Your Honor, if I may
Yes.
request, given the court's ruling, if Your Honor could order an expedited assembly of the record. Usually that takes a little time.
I'm happy to order that. I don't know, do you need a motion?
I may, Your Honor.
All right, if you write it out and give it to the clerk, I'll make sure I endorse it before I leave today.
Absolutely.
But certainly that is allowed.
Could I do a handwritten motion, Your Honor, without the acceptance
That's
of the
fine.
clerk?
Just as long as I can read it. All right.
Yes, Your Honor, absolutely.
Anything further?
No, nothing further on behalf of the Commonwealth. Thank you.
All right. Ms. Carter, please wait to meet with probation, and we are adjourned. Thank you very much.
All rise.
Sue, I'll bring this down to you in a couple of minutes. Okay? All those conditions are all written out, Sue. No. Yeah. Right here? All right. No, no, come on upstairs. Come on.
Orderly fashion, please. All right, Chad, thank you. Okay. Sorry.
So you got that off, right? Thanks.
All right, everybody. Well, I thank you for watching with me live here on the Fox News Now stream, as well as Fox 10 Phoenix Facebook Live and Fox 10 Extra from earlier today. You just heard the sentencing of Michelle Carter in that suicide texting case. If you missed it, just head to the video section on our YouTube page, search for Fox 10 Phoenix, and we will have the entire hearing clipped in full. Taking you to a live shot of New York City right now. Thank you for watching.